Session for the pretrial motion of People v. Price. Will the defense please present the evidence in question?
Your Honor, the defense requests the exclusion of the gas can found by Officer Benares in Mr. Price's truck on the account of the search violating Mr. Price's Fourth Amendment rights.
Could the defense please provide an example or similar situation which would relate to People v. Price?
There are similar cases in which the same fundamental rights have been violated, such as Reed v. Georgia. Just as in Reed v. Georgia, the defendant was seized based on a match of an informal criminal profile. In Reed v. Georgia, the court ruled that the evidence should be excluded from the case.
Could you expand on the similarities of the cases?
In both cases, the defendant was seized without reasonable and articulate suspicion. The court ruled that the defendant was seized unlawfully, and the evidence found would be excluded from the case. In People v. Price, Mr. Price was stopped at the checkpoint on account of matching every vague profile, as was the defendant in Reed v. Georgia. The court ruled that the defendant matching this broad, undescriptive profile did not constitute enough probable cause to stop him. Furthermore, the evidence found by the officer was excluded from the case due to the unestablished probable cause. According to this ruling, the stop of Seuthe Price based on a broad profile should be ruled as unconstitutional. However, even if the stop was lawful, the gas can should still be excluded from the case on the account of unlawful search.
So Officer Benares did search Seuthe Price's truck bed?
Yes, Your Honor. In Officer Benares' witness statement, he claims that only after leaning further into the bed, he had noticed the gas can. Therefore, Officer Benares had placed himself in an unnatural position to see further into the bed, which characterizes a search and renders the plain sight rule inapplicable. Seeing as Officer Benares had no search warrant, the gas can should be excluded from the case as evidence in order to uphold the values of the Fourth Amendment.
Are there any other cases you'd like to relate to People v. Price?
Yes, Your Honor. I'd like to bring up United States v. Morales-Zamora, in which the court ruled that the evidence be excluded from the trial because it also violated the Fourth Amendment rights.
How is this relevant to your case?
Well, Your Honor, law enforcement used checkpoints on the pretense of checking driver licenses and vehicle registration when the actual objective of the checkpoint was to find illegal contraband. The court ruled that the search of the defendant's vehicle was unconstitutional because the law enforcement officers did not solely serve the purpose of the road checkpoint and instead used it as a way to unreasonably search for drugs. The officers conducting this roadside checkpoint could have no reasonable suspicion to believe that every vehicle that they searched would carry illegal substances. Therefore, the police officers violated the defendant's Fourth Amendment rights by searching her vehicle without reasonable suspicion to believe that she was transporting illegal drugs. This case is similar to United States v. Morales-Zamora because the Mountainville Police Department conducted a roadside checkpoint on the pretense of checking driver's licenses and registration when their real motive was to find the culprit reasonable for the acts of vandalism and arson threats. For these reasons, the defense reasonably requests that you suppress the evidence of the gas can found in Seuthe Price's truck from the trial. Thank you, Your Honor.
The prosecution may begin now.
Your Honor, we request that you deny the defense's motion and allow the evidence of the gas can found in Seuthe Price's truck be used in the trial. See, the connections used from the several other court cases the defense used to connect to People v. Price are not valid arguments because they are not similar cases. For example, the defense used Reed v. Georgia and obviously had no relevance to our case whatsoever. The agent who seized the two suspects in Reed v. Georgia faced drastically different circumstances compared to Officer Benares. In Reed v. Georgia, the agent received a very vague profile of the drug dealer. The only information given to the agent was the suspect arrived in Fort Lauderdale early morning and the suspect had a shoulder bag. Officer Bernard was given a profile describing a suspect about college age with a disabled appearance, wearing ragged flannel shirts or t-shirts with political slogans, and combat boots or hiking shoes. The profile is much more specific than the one provided to the officer in Reed v. Georgia. Therefore, the court's ruling should not influence People v. Price. Furthermore, the evidence discovered in Reed v. Georgia was illegal contraband, unlike People v. Price, a gas can found in the back of Mr. Price's truck. Should not be compared to cocaine. We also like to establish no connection between United States versus Morales-Zamora as previously discussed by the defense. In United States, Morales versus Zamora, law enforcement officers check every car stopped at the checkpoint for drugs. But in People v. Price, Officer Bernardes didn't seize every passing car to look for similarities to an eco-terrorist. The checkpoint checked every 3 cars, and in Morales-Zamora checkpoint was also searching for drugs, not regulating traffic behavior in People v. Price. For these reasons, the prosecution would like to request that the evidence of the gas can be admitted. Thank you, Your Honor.
After reviewing the case, I decided to allow the gas can found in Mr. Price's truck to be admitted as evidence in People v. Price. Officer Bernardes had a reasonable cause to stop Mr. Price, because his vehicle and description matched the eco-terrorist profile. Furthermore, I find no discrepancies in Officer Bernardes' conduct after he stopped the vehicle. The plain in sight rule applies to the discovery of the gas can, because Bernardes made no effort to search Price's vehicle. I find that the cases the defense has brought up are not relevant enough to influence this ruling. Pre-trial motion is denied.
Yeah, I wanna party.
I won, bitch.
I won.